session.
Thank you very much. Please be seated. This is the time set for oral argument in Premier Physicians Group versus Navarro. For the appellant, let's begin with introductions.
Trevor Fish, Your Honor, and I also have from my firm, Attorney Lee Dove.
Thank you very much.
We represent the appellant Premier Physicians Group.
Thank you. For the appellee.
Good morning, Your Honors. Joel DeChancio and Christopher Robbins here on behalf of defendants Navarro.
Thank you very much. Let me go through a few preliminaries. First, let me advise counsel that the panel has read the briefs closely, has reviewed pertinent portions of the record, and we've also conferenced the case. So we're familiar with the issues and the arguments that you have raised in your briefing. Each side has 20 minutes. The appellant may reserve time for rebuttal. When you go to the lectern, if you would let us know perhaps your best estimate as to how much time you would like for rebuttal, we will do our best not to ask you so many questions that we poach on your rebuttal, so you'll end up with it. We are recording the proceedings today, both audio and video, and so even though we now know who you all are, when you go to the lectern, if you would please just restate your name. That way if someone is listening in, they'll know who is speaking. And with those preliminaries out of the way, we'll go ahead and begin.
And I'll plan on reserving about 5 minutes for rebuttal. Maybe a little bit more, we'll just see. To lean or not to lean, that's the issue before the court today, but it's also a question that faces, that medical providers face each and every day. The statute that we're asking interpretation of from this court is the healthcare provider liens, and that's found throughout ARS 33, 931 through 936, and particularly with regards to 33-932, which concerns the perfecting of a lien, the statement of the claim, and the recording effect. The issue before the court is going to be the timeliness of our client's statement of lien claim. As the court's aware, the statutes in this respect were created, it's approximately 1954. They were taken from the 1939 code, but they were put in effect 1954. They've been amended, renumbered, changed a bit, but essentially the case law states that the purpose of these healthcare provider liens has been threefold. The first purpose is to lessen the burden on medical providers, to give notice of a medical lien, and to determine priority among the medical liens. Now, in this particular case matter, there's no issue about the notice requirement. The appellee is not arguing that they were provided insufficient notice or that there was a problem with the mailing or anything in that respect. In actuality, the lien was recorded on September 16th, 2011, and the settlement for this particular case, in which proceeds were paid out, the case was settled by the insurance company. That didn't happen until almost 2 years later. It was March 28th, 2013. So we have almost 2 years that had passed. So there is no issue that they didn't get proper notice or that they didn't know about this. The lien had been recorded, it's there. They're just saying, hey, 31 days had passed since the first date of service, so that makes this one an invalid lien. So it's a technicality that they're trying to argue. But in actuality,
Well, it's kind of an important it's not just a technicality, it's kind of an important point because it invalidated your lien. But let me ask you this. What would be the hardship of filing a lien within 30 days?
Okay, There's a couple
30 days
things
of first service.
from the first service. Well, the reality of how these situations occur is you have a medical provider. In our case, we've been referencing chiropractic treatment and chiropractors. There's even the amicus brief from the Arizona Association of Chiropractors. In our particular case, actually, the services didn't arise from chiropractic treatment. It was actually pain management treatment from physicians, nurse practitioners. That's who provided all the medical bills that we're seeking recovery of. So the realities are that you have medical providers that will provide treatment in situations where there's a personal injury case, car accident, premises liability, something along those lines. The medical providers do it on a lien basis because the injured parties, they either don't have health insurance that will cover the treatment, or they just don't have the financial means to do a cash pay option. So someone will take a medical provider on a lien basis. So what happens is if you have a 30-day, what's essentially a 30-day statute of limitations, where you have to know within 30 days of your first day of treatment of how you're going to bill this case, you'll have someone that will start on a cash pay basis, or someone that will have insurance, will have health insurance, and they begin treatment, and then all of a sudden after 30 days, circumstances change, where that injured party no longer has health insurance, or they decide, hey, I don't have the money to do this cash pay, let's do it on a lien basis. Well, now if you take that super strict reading that the appellant is arguing for the interpretation of the statute, if you do that, 31 days pass since that first day of treatment, you can no longer lien a treatment, even though it's only been, say, 32 days after the accident. So that's a practical effect. If you do that, it creates a hardship to, it really voids the whole purpose of this statute that lessen the medical burden. So that's an issue. There's also an issue where the scope or the type of treatment changes. Let's say that someone goes and they see an orthopedic surgeon, and they meet for the first visit, and they determine, well, surgery's not needed, just continue your treatment with a physical therapist, with a chiropractor, and then something changes after the 30 days where the orthopedic surgeon re-examines the situation, says, no, it looks like you're going to need surgery. But in that case, 31 days have passed again, so you have an orthopedic surgeon that can't record a lien against the proceeds. So that's an effect of reading it the super restrictive way that they want. The other effect, you have...
You do have an ability, though, to go after the insured, who, in this case, was compensated and, in theory, owed them, and certainly owed the money to the provider.
Yeah, not the insured, the tortfeasor. That's who we've named it. The same thing for this case. The tortfeasor, the insured that we've named. The medical provider would have a contract case against the actual injured party, and that's the injured party is not named in this case. And yes, we do have a contract case against the injured party. But what happened in this case, and what often happens, is you'll have someone who is unrepresented. They don't have a plaintiff personal injury attorney, and they settle a case on their own. If you have a plaintiff personal injury attorney, when they settle the case, they're taking the settlement funds, they're putting it in their trust account, they're ensuring that medical providers are getting paid, that these liens are getting paid. That's what will usually happen. But in this case, without the plaintiff personal injury attorney, it's just that injured party that takes the settlement funds. And then that's the problem, is you have someone that's, for all intents and purposes, judgment proof, or they have cash in hand, they have other responsibilities, other obligations. It's just too tempting for them to take that money and pay off something else. That doesn't relieve them of the obligation to do it, but the practical effect is that the funds are gone. The settlement
Another
proceeds.
question: is there a deadline under your theory if the care is ongoing and someone, the provider says this person is going to need care for the next 10 years? In your view, is there a deadline for filing the lien?
Well, it has to be related to the treatment, and as the statute says, to the injuries. It is services relating to the injuries. So if they're still under care, if there's still ongoing treatment, there is a situation. I'm sure they're going to argue one extreme. I'll argue the other.
That's the extreme I'm asking you about right now. There's the provider has recommended
a year
this
of
is
treatment.
Let's say 3 years of treatment, and it's ongoing. Can you wait to file the lien until? Is there some deadline, and what's your authority for what what date you would choose to file it.
Yeah, well, no authority, that's the problem with the case, that's why we're here. There's no authority for it, but in that circumstance, so let's say it did go on for 3 years, and they don't record their lien until 3 years, they would still, I'm arguing, they would still have the right to do that, to record that lien, but their priority is going to be affected. They're not going to be in priority with the other medical providers, and they may have missed out. The settlement could have already happened. So that's the risk that a medical provider runs if they're going to wait to do that. And it's no harm, no foul to the insurance company, to the insured party. If they've already settled the case after 2 years, then that lien, there's nothing to lien. There's no settlement proceeds. So they're not hurt. They're not harmed. If they haven't settled the case yet, as litigation goes on, then there's still a valid lien claim. And they still, if they've received notice of it and they haven't paid out, they haven't settled, then fine, there's still the funds to go after. So there's not really a harm that the insurance company or insured party are going to suffer, that even if it did go 3 years. They may try to argue something along those lines, that they're not going to have notice, that they're not going to know about this. But the reality is the personal injury claims are based on the medical services provided.
Mr. Fish, let me go back to Judge Orozco's question about the hardship a healthcare provider might sustain if we were to decide that, well, 30 days really does mean after the first services. The statute requires the verified statement to just simply say whether the patient's treatment has been terminated or will be continued. Then amounts incurred during the continued period are also subject to the lien. And so if the patient comes in and let's say they have a back injury, and so, there's some uncertainty there as to how long. But the healthcare provider is not required to give an ironclad, they're going to need surgery or not. It's just that, okay, here's the treatment. It's going to continue. It's going to be ongoing. And then subsequent amounts will be covered. So I go back to Judge Orozco's question. There doesn't seem to be a lot of hardship there.
Well, that's the best practice for them to record early on,
Well,
because,
yes.
because it's the lien priority.
Yeah, right.
And isn't that something that would be asked just immediately, initially, when someone comes in? You're there for a reason, and wouldn't that be a simple question? Is there a possibility that someone may be responsible? And if there is that possibility, even if they're going to pay cash or they have their own insurance, why not make that assessment up front and then just put everyone on notice?
Yeah, if they're already paying cash, then you can't lien. Actually, that may be an improper. They have the medical ethics that they have to comply with. They can't really lien settlement proceeds if someone's paying cash. So if they're claiming a lien on something that's either being paid by cash or being paid by health insurance, I don't know that they would actually be permitted to file that statement, because it's a verified statement that they have to file.
You're saying that may well be as a matter of medical ethics, but I don't recall anything in the lien statutes.
Well,
I'm mulling here.
yeah, and the lien statutes, because it's going to reference the amount claimed due for health care. So they're alleging that a certain amount's due. If they've already been paid for those services, or they're billing insurance.
If a healthcare provider were to record a lien, and then let's say the patient ended up deciding to pay out of pocket, the healthcare provider can record, or rather file, I guess it is, record a waiver or a lien. It's not
like an amended lien.
Yes,
or
or just satisfaction of lien or satisfaction of payment. So that everything is then cleared up.
Yeah, I don't think it'd be a problem going the reverse situation, going on a lien basis and change that later on. But the way that the statute's written, you have to state the amount that you're claiming due for health care. So I'm arguing, I believe that'd be improper to claim a lien if you're already being paid.
Doesn't 33-932, it deals with perfection. But that doesn't mean that the healthcare provider is going to then enforce the lien. This is just, have you done everything to perfect? But perfection is not the same as, I have a legal right to enforce my lien.
But they are making,
Next step.
Yeah, they are making a verified statement that amounts are due and owed for health care. So that's the big issue, the big problem I see, that it wouldn't be in full compliance with the statute, and there's also maybe medical ethic rules involved as well. But there really is 3 different ways to interpret this statute, and I think we referenced it in our opening brief of the issues before the court. The 3 ways to interpret this is you take the appellee's argument that it has to be within 30 days of the first day of treatment, even though it doesn't say first anywhere in the statute. It doesn't say, anything about that first day. But if you could take that interpretation, you could take our interpretation of that it's 30 days within any treatment, including the final last day of treatment, or you can interpret it to be that it's the preceding 30 days. That's what the legislator intended it to be, just like the mechanics lien statutes or any of the other lien statutes, that it will give, like the mechanics lien, it's a 20-day notice, and it covers everything the preceding 20 days on forward.
What do we do with the context of the discussion regarding what hospitals have to do? You seem to be suggesting that the providers can do just what the hospital does. As long as they do it within 30 days after the last treatment, you're fine.
And I'm glad you brought that up when you did, because that goes right into that next point. Differentiating between hospitals and other medical providers. The appellees make a big deal out of that hospitals are treated different, that the legislative intent is that they're treated different. They even reference the House bill, the 2004, the notes for the House bill in 2004. But that's 2004. That's after the hospitals successfully lobbied for the change of the statute. The statute changed big time in 2004. Before that, and what you actually need to do is go back and look at how the statute read before 1988. If you look how it read before 1988, it says, and this is just dealing with hospitals, it says that they record the lien before or within 30 days after the patient is discharged from the hospital. So, that's just reference to hospital. 1988, they amend it. They include medical providers.
Yes, but they didn't, I've got a copy of that as well.
They
They didn't
add
use the
in
same
all.
language.
Yeah, it's exact same language. Yeah, 1988, where it talks about any.
Well, yes, but the language that we have today in subsection A is the language that was initially used by the legislature that seems to draw a distinction between hospitals, which can record their lien 30 days after discharge, the patient's discharge, and a healthcare provider.
Yep.
And the discharge provision is only applicable to hospitals.
So if you're back in 1988 and you're thinking of terminology to use, and you want the medical providers to be treated exactly the same as the hospitals, it seems like that's what they state is any services relating to the injuries. They can't use discharge because it's different. The hospitals are discharging a patient. Medical treatments, medical providers, there's treatment that you don't necessarily discharge a patient from. Sometimes they're under the care and you can say that they're discharged from care, but you can't say that a medical provider discharges a patient, because sometimes medical providers are doing services which you couldn't say it's being discharged. So that's my argument, is that 1988 is that legislator intended, they actually did intend to treat the same hospitals as medical providers. The only thing they did is give priority to the hospitals. I mean, they did do that. But the rest of that, the statute where they talk about notice requirements not necessary, that they don't have to name, then hospitals don't have to name all the parties, and hospitals can recover 30 days before settlement regardless. That was all done in 2004. That's when everything was changed. And that's where I'm arguing we can't look at intent of 2004 when the statute was actually changed in 1988. That's what we have to go back to 1988 to determine intent. And the differences between hospitals and medical providers, it really wasn't as imperative, it wasn't as big of an issue in 1988. So that's my argument with regards to that. And so they're treated the same in that one respect. So what? I mean, the hospitals have so many other benefits at the rest of the statute, with being that they don't have to record, that it can be 30 days before a settlement proceeds. So hospitals are plenty protected. This shouldn't be an issue that both of them apply to the last day of treatment. I mean, that's a non-issue, it really is. And I see I only have 2.5 minutes left. I'll close here unless there's any other questions, just so I save some time for rebuttal.
Okay. Thank you.
In your honor, that was Trevor Fish for the appellant. He didn't announce that at the very beginning. So
I
put that on the record.
you know,
We will,
he doesn't want to be claimed for, you know, just so
We-
there's no confusion.
we will forgive that, not to worry. Okay.
Thank you, Your Honors.
Good morning, Your Honors. Joel DeChancio on behalf of Defendants Navarro. May it please the court and counsel. Let me dispense with one thing very quickly. For every argument they make about how to interpret the word any, we make a similar argument. When they say any means any date of service, we can say any means any type of service. So once you do one thing, exam, evaluation, shot, prescribed medication, the clock starts to tick. When they say if the legislature intended it to be the first date of treatment, they could have said first day of treatment, then we can turn and say if the legislature intended it to say last date of treatment, legislature could have said last day of treatment. Or better yet, they could have said the same thing they said with hospitals, so the date of discharge. I didn't understand the argument about discharge. Every medical provider I've ever seen does have discharge reports, so I don't know why any medical provider couldn't discharge a patient. That's typically the word they use when they end their treatment. So if the legislature intended it to be 30 days from discharge, which is what they're arguing essentially, doesn't make sense that they would describe it differently in the exact same sentence in the statute.
What is your, sorry, go ahead.
So is it your contention then that they come in for an examination, the 30 days starts to run for that examination. They come in for, they're getting treated, they're being followed, maybe they get some epidural shots. So now it's a different type of service. They have 30 days from the first epidural shot. The epidural shots don't work, so they decide to do surgery. So it's 30 days from the surgery. Is that your contention, that they can, for every type of service, they can come in and file? It's 30 days. It's not 30 days from the very first time they walk in the door and say, I'm here to be seen for whatever.
Well, what we would suggest is the first time they walk in the door, they're receiving services. That's when they receive services, is when they meet with a doctor and something happens. That's what we think the statute was intended to start the clock, when they received any services. And here's the reason why. The distinction with hospitals is not just a big deal. It is a big deal, but it's not a so what argument as they indicate. When hospitals and ambulances who are treated differently, when they see a patient for the first time, when the first services are rendered, they're often being wheeled in a gurney in the emergency room, and it's not really the time to sit down and say, who hit you, what insurance coverage do they have, give us information concerning the tort. That's why they're treated differently. When someone goes to a chiropractor or an orthopedic surgeon outside the hospital context, or a physical therapist, typically in that kind of a context, they've had time, they've maybe been contacted by an insurance company, they have claim number information, they have the name of the tortfeasor, they have all of that kind of information, and you'll often see with most of these providers, they fill out an injury questionnaire which asks for all this information. So to treat them differently than hospitals is completely rational and consistent with the rest of the statute.
What's your response to the argument that someone comes in as a cash-paying customer and just develops later on? Initially, this may just be, my back's sore, I've got treatment, and I'm paying out of pocket. Could they file a lien at that point? And if someone just came in the first time, but then 30 days later they decide this is not getting better, I'm going to need more treatment, is the provider just completely out of luck under that scenario?
Well, first of all, Your Honor, that never happens. In the real world, that never happens. But let's say hypothetically that it does. The reason that the statute and their argument makes no sense in that regard to answer that question is that now they're asking you to ignore the rest of 33932, which is what we call the strict compliance provision. So while I would say yes, once they provide services, their clock starts to run.
But can they file a lien if someone has paid cash for their services?
There's nothing in the statute that prevents it. The statute doesn't say, for example, you file a lien for usual and customary charges that have not been paid. It doesn't say that. That's why I'm saying that never happens in real life. If they have insurance, and what does happen in real life is people go...
Insurance through their employer.
Right, and so what does happen in real life is that people go to the doctor, the doctor files a lien for the full retail amount of the charges, then health insurance at some point down the road makes payment, and then that reduces the amount of the lien. The lien statute specifically says, with the hardship issue, that not only did they get the charges at the time of the lien, But the statute was amended to say, and any treatment thereafter. They don't have to refile the lien. They don't have to do anything.
So to follow up, and I appreciate your discussion about what goes on in the real world, but that's not part of this record. I mean, if we wanted to find out what was going on in the real world, there needed to be affidavits and information as part of this record, and we don't have it. But looking at the language of the statute, subsection B, the verified statement shall also include the amount claimed due as of the date of recording. So getting back to Judge Catani's questions, I come in, I see my doctor, I pay cash. Maybe I'm nuts, but I pay cash. Then I come back 45 days later. The doctor hasn't, what happens here? I take it that the statute just doesn't address the situation, is what I'm seeing here.
Here's what I think happens. I think the statute does address the situation in that it doesn't, that filing the lien and recording the lien does not depend on whether there's a payor, because.
That's right. I think it's 33933 or 34 or something like that.
Right, and so it doesn't address payment. So when you come in, if somebody comes into your office and you believe that this is a case that might apply to the lien statute and you want to use this tool as a method to recover your compensation, then you're required to file the lien. And here's the other reason why. Because 932 goes on to provide what we call the strict compliance provision. And that was one of the things that was amended in 2004. The language about any services, that wasn't, contrary to their argument, wasn't amended in 2004. I think that language existed before that amendment. But what did happen in 2004 is people that were interested in settling tort claims, and of course this state has a public policy favoring settlement, they wanted to know that when it was time to settle a case, we want to be able to look at the county recorder's website and we want to know if there's any valid liens we need to take care of. Because the liens not enforceable against the patient under the statute. It's enforceable against the tortfeasor and the tortfeasor's insurer. So tortfeasors and insurers have a right to know what liens can be enforced. And they didn't want to have an argument later that, well, we substantially complied with the recording. It wasn't 30 days, but it was 34 days. And like he said, we sent it to you a year before settlement. That wasn't good enough. We needed to know what liens were valid. And so the statute was amended to say, if you don't strictly follow the recording sections of the statute, you have no cause of action to enforce this lien. And so it's a bright line rule. There has to be a cutoff. It's 30 days. And if they record the lien 31 days, that's the cutoff. And so there is a purpose for it. So this whole argument about hardship, I think you got to the heart of it with hardship. There's no hardship to the provider, first of all, because these providers, unlike hospitals, have the benefit of getting information from their patient that hospitals don't. They have 30 days to file that lien if they want to protect it under the statute. They have all the information they need. And as 932 says, amounts incurred during the continued period are also subject to the lien. So in that situation he gave you about they come in with a back injury and we just tell them to get physical therapy for now, they might need surgery in 10 years. Well, there's no hardship to them because if they file the lien on that first date and it turns out the patient needs surgery, all those charges, if it's related to the accident or the tort, all those charges are subject to the lien.
Well, what is the hardship to the tortfeasor in recording it 30 days after any service, as they have indicated?
Well, for a couple reasons. One, it's not so much that it's a hardship to the tortfeasor, but there has to be a bright line rule so that settlements can be done. If the statute said 30 days from date of discharge, then 30 days from date of discharge would be okay. But some cases get settled quickly, especially small cases, and they might get settled within the first 30 days of a claim. And that's what we want to happen public policy wise. So by stretching out the lien date doesn't do anybody any good with respect to carrying out settlement. But the fact of the matter is the legislature says 30 days. They say it in the same sentence as the 30 days from date of discharge. And to have the legislature in one sentence say providers must file 30 days from any service except hospitals 30 days from discharge, to interpret it the way they're suggesting, hardship or not, would render portions of that phrase superfluous and certainly contradictory to the rest of the statute that gives hospitals the right to file late recorded liens, Hospitals don't have to provide as much information on the lien notice. The statute's replete with examples of how hospitals are treated because of the nature of
Would
their
you agree
emergent
without the
treatment.
language relating to hospitals that you could read 30 days from any services wouldn't necessarily be the first services?
In a vacuum, yes, Your Honor, because we're not suggesting that their interpretation is wrong, but or their interpretation is not reasonable. When you look at the word any, you can interpret it in many ways, and that's why the rules of construction say when we have a statute that where a important word or phrase is susceptible to more than one interpretation, we follow certain rules. One thing we do is we look at the context. So in this particular case, we look at the context. Any services is in the same sentence with 30 days from discharge. If any services meant 30 days from discharge, then why say any services? It can't mean the same thing as 30 days from discharge, but they're arguing that it does mean the same thing as 30 days from discharge. We don't interpret statutes that way. That renders that whole phrase meaningless. We look at legislative history. And the reason that we cited the fact sheet's not a version of the bill. What it really is it's facts being presented to, when a bill is presented, facts being presented to the legislators to give them information about the statute. And it's a legitimate part of legislative history. And in the fact sheet for the 2004 amendment, it says, in order to perfect a medical lien, the healthcare provider must record a verified statement with the county recorder. I'll skip a little. Within 30 days of the beginning of medical services or the patient's discharge. And that sentence, it's lumping all the providers together, hospitals and everyone else, and it differentiates just like the statute does. So to answer your question the long way is in the absence of everything else, yes, you could interpret any to mean any date of service, but when you look at the context, you look at the legislative history, you look at the superfluousness of their interpretation, and you look at the fact that there's a huge distinction between hospitals and other providers all the way throughout the statute, and the purpose of enforcing the strict compliance provision to support the policy in favor of settlements, then I think that does render our interpretation appropriate.
On that fact sheet from 2004, I must say, I thought it kind of perhaps muddied the waters a little bit, because as I read it's the first sentence on page 1, and I think next to last full paragraph, beginning with in order to perfect a medical lien, the healthcare providers, not talking about a hospital, but talking about a healthcare provider, must record a verified statement with the county recorder in the county where the provider is located within 30 days of the beginning of medical services or the patient's discharge. Isn't that contrary to the argument you're raising?
Not at all, Your Honor. And the reason that is because if you're going to take that and interpret that sentence to mean that referred only to chiropractors, physical therapists, and everybody,
It talks about healthcare providers, and there's when in this statutory scheme, they wanted to talk about healthcare providers, they said healthcare providers. When they wanted to talk about hospitals, or now ambulance services, they talked about hospitals.
Yeah, but this is a fact sheet that's more generic. But let me refer you to 33931, which when given the lien right, says every individual partnership, et cetera, healthcare institution or provides healthcare services in this state. So to use the word healthcare provider is consistent with 33931, which talks about everybody, any entity that provides healthcare services. So to interpret this fact sheet to suggest that healthcare provider means one type of provider and not all of them isn't entirely consistent with the statute. But more importantly, Your Honor, it would be absurd to have two standards.
I only point that out because I looked at that and I went, that's a little mushy. But we have to look at the language of the statute.
Right, and it is a little mushy, and that's why we cite legislative history, because what we're trying to do here, what we're trying to accomplish is we're trying to accomplish determining the legislative intent, and we do that by looking at the words. Okay, so we've done that here. We've looked at the words. They say any could mean this. We say any could mean that. We're at a stalemate. They say the legislature could have said this if you want to buy their interpretation. We say the legislature could have said that if you wanted their interpretation. So we're stuck going to plan B. We have to go down the hierarchy of construction. So when we go down that rung, the first thing we do is we look at the context. And that's why I bring you back to just the fact that the statute itself, let me just reference it just to be specific. The statute itself for 33932 in the same, it reads, in order to perfect a lien granted by 33931, the executive officer, licensed healthcare provider, or agent of a healthcare provider shall record before or within 30 days after the patient has received any services relating to the injuries, except a hospital, which shall record within 30 days after the patient is discharged. So and let me address one thing you just said too, Your Honor. This statute actually does talk about licensed healthcare providers lumping hospitals and the other providers together, because it says licensed healthcare providers shall record, and then it accepts hospitals from that. So that answers that. But the point, Your Honor, is that in one sentence, the legislature and the statute sets forth two standards for recording. Their interpretation, they ask you to reach a conclusion that any date of service is the functional equivalent of 30 days from discharge. To read a statute that has in one sentence two standards that mean the exact same thing is absurd.
What about, and this was, I think, not really the position taken in the opening brief or the reply brief, that there is a third way to interpret the statute, that it is, the lien must be recorded 30 days after any service, and then, of course, the lien would only cover amounts due subsequently. So you would end up losing your lien right, or provider would lose lien rights for anything that came before it. That was the point that was raised in argument here.
Yeah, and that I don't buy as being an equally rational interpretation, and here's why. If the legislature wanted to, it doesn't make any sense that the legislature would have different recording provisions at different times. It would either be the first or the last. And the reason why I don't think it's in the middle is because if the legislature contemplated a scenario whereby you could record sometime after 30 days after treatment started, but still recover at least some portion of your lien, then they would typically have a provision in there that would say, and here's what you get to recover in those circumstances. So it should say, if you record on the first day of service, 30 days, you get to collect your whole lien. And it wouldn't make any sense if you did it 30 days from the last date of service, then there isn't any treatment in between your filing and your lien.
Why wouldn't it make sense, though, to say, as long as you record within 30 days that you're covered for the services that have been provided for the last 30 days and prospectively? And that would satisfy their issue of if someone's come in with cash or whatever. Wouldn't that at least make sense that you've recorded within 30 days of some services, and that's the only thing you get a lien for is what you recorded?
It could potentially make sense if the statute said that, but the statute doesn't say that. And I guess that's my argument, is that if the legislature intended to permit that kind of a recording provision, then it would necessarily need a provision after that says, and in the event you record 30 days in the middle of treatment, you are entitled to recover X through X. Because
wasn't some of the focus of the legislation to avoid forcing providers to continually record, to say once you've recorded, this is prospective, we're not going to make you file at the end of every month? I've forgotten which aspect of the legislative history that was, but that would seem to suggest that we're just interested in getting something on file prospectively, and it doesn't necessarily dictate when you have to do that, as long as it's there and everybody's on notice prior to a settlement.
Actually, it does dictate, in my opinion, Your Honor, it does dictate when you're supposed to do it. You do what the statute says is that once you file the lien, you're required to notify at the time you record what amount is due. But then the statute says, then anything after you do that notice and record, we're going to take some hardship away from them by permitting any other charge that happens thereafter that's not in that amount that you've stated is going to also apply to the lien. And the thought being that the purpose of it is to say, okay, here's when your lien is filed. It's a valid lien. We want strict compliance with your recording because we need to know if you have a valid lien. Now we can look at the recording and we can see the amount of the lien. Then we can go one step further and call the provider and say, okay, you filed a lien for $4,000 on day 28. Are there any other charges that you're claiming for that lien from that time forward to the present, so that we can incorporate that into the lien? That was the purpose of that provision. It wasn't to affect the recording provision. It was to lessen the hardship on having to continually amend the lien. So that's the problem with their hardship argument, is they don't have a hardship argument. Once they file the lien, all they have to do is comply with the recording provision, which is, as we've argued for all the reasons, 30 days from the beginning of any service, or 30 days from any service, whether it's whatever happens on that first date. And once they do that, they are golden for the rest of the time. The rest of their treatment is subject to the lien. They have to take no further action. So their hardship argument really doesn't have any merit for that regard. I only have 15 seconds left. Any other questions?
I'm still, I hate to just belabor I think Judge Orozco's question, just the hardship to your client. It's hard to find any hardship if they're on notice prior to settlement, and it seems like they already have the incentive to file. But you're not arguing any hardship. You're just saying this is the language of the statute.
Well, there could be hardship. That's the problem, Your Honors. Before the 2004 amendment, that when a lien was filed late, not according to the terms of the statute, then the argument that they would get in having to litigate whether or not the lien was valid is we substantially complied. And that was causing a problem with settlements. Settlements are highly valued in public policy in Arizona, and we wanted certainty. And that's what the purpose of the statute was to provide certainty. So there is a hardship when you're trying to settle claims and you can't determine whether that claim incorporates liens because you can't determine whether they're valid or not because you don't know where the bright line is. That's a problem. This statute solved that. This amendment solved it by giving us a bright line and said if you don't get it by the time the statute says, you're out of luck and you have no cause of action. So therefore, we'd ask that you affirm the trial court. Thank you.
Now, the purpose isn't really of the statute to provide certainty. The purpose is what we went, the threefold, and one of the purposes is to protect medical providers, to lessen that burden of the medical expenses. So if we're looking at what the purpose of the statute, that is cited case law. It says what the purpose is. No case law says it's to provide certainty. It's to protect the medical providers. You heard...
They are protected as long as they file the first time somebody comes in, within 30 days of the first time they come in. They are protected, right?
They would be protected under that case. They'd be protected if they file within 30 days of any service. So there's.
What is your response? Doesn't it make sense to try to encourage your early settlements? And doesn't it make more sense to have something recorded immediately after the first visit? And if someone wants to settle within
It
3
protects
months of an incident?
It offers better protection. It certainly does. And again, if we're talking about the priority of liens. So there is a benefit. There is definitely incentive to record earlier rather than later. But when we're talking about, like in this case, of recording within 31 days of the first day of treatment, the settlement's not happening, 30 days from the accident. Settlement like this case is happening, 2.5, 3 years later. So there's plenty of time to record the lien. There shouldn't be that the interpretation that they're talking about is that first day of service, that the clock starts from the first day of service. That's what counsel said. And you heard at the end, counsel, when he was citing the statute, and he didn't do it purposely, but had included the word the beginning date of service, and then he corrected himself, any date of service. Well, you see how easy it is to put that word beginning in there? The legislature didn't do that. They could have done that. So we keep talking about, what the intent could be for this, what the intent could be for that. But if we look at just the strict phrasing, just the actual words, and if we just give it the plain meaning and look at the words that's there, it can be interpreted any.
Mr. Fisher, you raise a very strong argument, but I keep coming back to the language of the statute, and there is a distinction, at least on its face, between hospitals and healthcare providers, and the use of the word discharge. And I don't see a way to get to your conclusion based on that language.
Let's take like x-rays, x-ray technicians that are doing that. They're a medical provider. They're not discharging a patient. That would be inappropriate to use that word, that they're discharging the patient. They're providing services, an x-ray tech, all sorts of medical providers that can provide services. It'd be inappropriate to
But
use.
the language suggests the conclusion of services, and the statute makes clear that with hospitals, it's at the conclusion, whether we use the term discharge, but
Absolutely.
you're done.
Yep.
And that's different language than for any other providers. They don't say when you're done.
Yep.
It-
Exactly, and that's the crux of this case, is we're left with the word any services. So what does that mean? And if there's different ways to interpret a statute, of course, we know that the courts are to interpret it the way that's most liberal and allows for recovery. And that's why we go back to the purpose of the statute. The only other thing I wanted to reference is one of the cases that we'd cited, the Black and Baker case, v. Jonovich. They make a reference there. It's dicta. There's no case that's precisely on point for this particular matter, but they reference in there, that's the 9th paragraph on page 3.
Could you just give us the site?
Yep.
Yeah.
It's Black and Baker v. Jonovich, 205 Arizona 383. And it's in section 2, it's paragraph 9 of the decision. And they reference, they say the filing must occur within 30 days after the patient had received the services. So they're saying the services, they're not using the phrase any, but they definitely don't say the patient had received the beginning of services, the first day services. They're just talking about the services. And that's what kind of leaves it open to where that other interpretation that we've been talking about, that it would recover 30 days of treatment. That's the way that the mechanics lien statutes are. It could be interpreted that way. There's the 3 different ways to interpret it. And unless there's anything further from the court.
Thank you very much.
Thank you for your time.
We appreciate your briefing and your argument today. We'll take this matter under advisement and issue a decision in due course. Thank you very much.